It is important to also recognize the attacks by Hamas did not happen in a vacuum. The Palestinian people have been subjected to 56 years of suffocating occupation. They have seen their land steadily devoured by settlements and plagued by violence, their economy stifled, their people displaced, and their homes demolished. Their hopes for a political solution to their plight have been vanishing. But the grievances of the Palestinian people cannot justify the appalling attacks by Hamas, and those appalling attacks cannot justify the collective punishment of the Palestinian people.
Folks, you cannot turn on your TV or log into your social media account without hearing something about the current Israel-Palestine conflict. So this video will evaluate and discuss the applicability of the principles of self-defense under international law, specifically Article 51 of the United Nations Charter, to Israel's current siege of Gaza. But first, let's understand the following. What does the United Nations Charter say about the use of force and self-defense? When can a nation state exercise self-defense under international law? Are there any limits to this right of self-defense? So the first issue, does self-defense even apply to the current Israeli-Palestine conflict? Some commentators have argued that it is a legal and logical impossibility for Israel, an occupying power, to apply the principles of self-defense to Gaza because it is already, quote, in an offensive posture, unquote. Israel's control over the West Bank, including East Jerusalem and the Gaza Strip, has led to its designation as a quote-unquote occupying power under international law, specifically under the Fourth Geneva Convention. The United Nations Security Council, the General Assembly, and the International Court of Justice have all referred to Israel as an occupying power in these territories. UN Security Council 242 emphasizes the, quote, inadmissibility of the acquisition of territory by war, unquote, and calls for the withdrawal of Israeli armed forces from the territories occupied in the 1967 conflict. UN General Assembly Resolution 58-292 affirms that the Palestinian territory occupied since 1967, including East Jerusalem, remains integral to the Palestinian territory. UN General Assembly Resolution 45-130 states with respect to the, quote, deterioration of the situation of the Palestinian people in the occupied territories that the UN General Assembly, quote, reaffirms the legitimacy of the struggle of the peoples for independence, territorial integrity, national unity, and liberation from colonial domination, apartheid, and foreign occupation by all available means, including armed struggle, unquote. Furthermore, the International Court of Justice, in its advisory opinion on the legal consequences of the construction of the wall in occupied Palestinian territory, also affirmed the position that Israel is an occupying power. In fact, the ICJ just announced that it will be holding hearings in February of 2024 to issue an advisory opinion on the consequences of Israel's occupation of Palestine. Now, let's talk about the Fourth Geneva Convention. The Fourth Geneva Convention of 1949 is the primary international treaty that governs the rights and protections afforded to civilians in times of war and occupation. Israel is a signatory to this convention. Article 42 of the Hague Regulations of 1907 defines a territory as occupied when it is placed under the effective control of a hostile army. As an occupying power, Israel has specific legal obligations under international humanitarian law, which outlines the rights and protections afforded to civilians in occupied territories, specifically humane treatment of civilians under Articles 27-34 of the Fourth Geneva Convention. Remember, Gaza is a 25-mile by 5-mile strip of land that is widely regarded as an open-air concentration camp. It is surrounded by a massive security fence. It is one of the most densely populated areas of the world, with more than 2.1 million Palestinians crammed into that space, with nearly half of them being children. Israel controls everything that comes into and out of Gaza, including food and medical supplies. 54% of Gazans are food insecure, and over 75% are aid recipients. Gazans are locked inside this territory and cannot leave except for permits that the Israeli government issues at their discretion. There is no airport, no seaport, no bus system, nothing. If they try to get close to the fence, they will be shot. If Gazans try to flee by boat through the Mediterranean Sea, they will be shot 6 miles offshore. Israeli forces restrict access off the Gaza coast, currently allowing fishermen to access 50% of the fishing waters allocated for this purpose under the Oslo Accords. According to the United Nations, quote, "The Gaza blockade through land, air, and sea is a denial of basic human rights in contravention of international law and amounts to collective punishment," unquote. Now, let's get to the second issue. If we assume that the principles of self-defense still apply, has the Israeli response complied with the requirements of international law? Now remember, folks, international law prohibits the use of force by one state against another. This is enshrined in Article 2.4 of the United Nations Charter, which says, "All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state, or in any other manner inconsistent with the purposes of the United Nations." The only exception to this rule is Article 51 of the United Nations Charter, which says, and I quote, "Nothing in the present charter shall impair the inherent right of individual or collective self-defense if an armed attack occurs against a member of the United Nations, until the Security Council has taken measures necessary to maintain international peace and security." Here are the key legal principles to keep in mind. Number one, necessity. Self-defense must be a last resort, used only when peaceful means have been exhausted. Number two, proportionality. The use of force must be proportionate to the threat faced. Number three, imminence. The threat or armed attack must be imminent. Now, what is an armed attack? The term armed attack under international law is a critical concept, specifically when considering the right of self-defense under Article 51 of the United Nations Charter. While the Charter itself does not provide a detailed definition, the interpretation of what constitutes an armed attack has been elaborated upon through case law, state practice, and scholarly analysis. Here is some key case law to keep in mind. Nicaragua versus the United States, 1986. Nicaragua filed a case against the United States alleging that the U.S. had violated international law by supporting Contra rebels in their insurgency against the Nicaraguan government and by mining Nicaragua's harbors. Here are the key findings of the ICJ, the International Court of Justice, on this case. Number one, there is a distinction between use of force and armed attack. The court drew a distinction between the, quote, "most grave forms of the use of force," which constitutes an armed attack, and other less grave forms. Not every use of force, even if it is in violation of the UN Charter, can be categorized as a, quote, "armed attack." Number two, the scale and effects. The court emphasized that the scale and effects of the use of force are critical in determining whether it qualifies as an armed attack. Minor border incidents, for instance, might not meet that threshold. Acts by non-state actors. The court recognized that large-scale attacks by non-state actors, like rebel groups, could qualify as an armed attack, triggering the right of self-defense. However, the court found that the support provided by the U.S. to the Contras, while in violation of international law, did not constitute an armed attack. Now, for an act by a non-state actor to be attributed to a state, thus constitute an armed attack by that state, there must be evidence of, quote, "effective control by that state over the operations in which the non-state actors are engaged." The court found in that case that the U.S. had not exerted such control over the Contras. Next, we have the case of oil platforms, Iran versus U.S., 2003. The case revolved around the destruction of 3 Iranian oil platforms by the United States in the 1980s. The U.S. justified its actions by invoking the right of self-defense under Article 51 of the United Nations Charter, claiming that the attacks on the platforms were in response to earlier attacks by Iran on vessels, that the platforms were being used for military purposes. The court examined the incidents cited by the U.S. to determine whether they met the threshold for armed attack. And it concluded that the mining of the single U.S. vessel, the USS Samuel B. Roberts, could not be considered an armed attack by Iran. Similarly, the court found that the incidents involving the Sea Isle City and the U.S. frigate Stark, while regrettable, did not cumulatively constitute an armed attack by Iran against the United States. Now, while this case primarily dealt with the definition of armed attack, the principle of proportionality was also implicitly addressed. The court seemed to suggest that even if the incidents cited by the US were considered an armed attack, the US's response, destroying the oil platforms for Iran, might not have been proportionate. Now, the United States invoked Article 51 following the terrorist attacks of September 11, 2001. This was a significant moment in international law as it expanded the concept of armed attack to include significant acts of terrorism. So based on this case law, tell us what you think about whether the October 7th attack by Hamas was, according to you, an armed attack within the meaning of international law so as to trigger Israel's Article 51 right of self-defense. We would be interested to know. The next issue, has the Israeli response been proportional? Remember, the principle of proportionality is a cornerstone of international humanitarian law and is crucial when assessing the legality of military actions, especially in the context of occupation or conflict. Here are the key treaties. The Hague Regulations, 1907. Article 27 emphasizes the protection of civilians and states that in sieges and bombardments, all necessary steps must be taken to spare as much as possible buildings dedicated to religion, art, science, charitable purposes, historic monuments, and hospitals. The Fourth Geneva Convention, Article 53, prohibits any destruction of real or personal property by the occupying power, except where such destruction is rendered absolutely necessary by military operations. The Additional Protocol 1 to the Geneva Conventions, Article 51, subsection 5b, states that an attack which may be expected to cause incidental loss of civilian life, injury to civilians, or damage to civilian objects is considered excessive in relation to the concrete and direct military advantage anticipated. So, the principle of proportionality requires that the harm caused to civilians or civilian property must not be excessive in relation to the concrete and direct military advantages anticipated. Given the significant civilian casualties resulting from Israel's bombarding of Gaza, questions arise regarding the proportionality of these actions. The scale and destruction, especially when civilian infrastructure like hospitals, schools, and residential buildings are affected, further accentuates these concerns. Just yesterday, it was reported that Israel bombed the Gaza Strip with more than 12,000 tons of explosives, equivalent to the power of the nuclear bomb dropped on Hiroshima. According to latest reports, the death toll in Gaza now exceeds 5,000 people, and more than 15,273 people have been injured. Women and children make up more than 62% of these fatalities. Furthermore, 35 UN staff members providing aid and assistance to civilians on the ground in Gaza have been killed, and 18 staffers have been injured. Nearly 600,000 internally displaced persons are sheltering in UN-provided facilities in the Strip. They have no food, no water, no electricity. While Israel may argue that its actions are aimed at neutralizing threats from militant groups operating within densely populated areas, the principle of proportionality mandates a careful balancing act. The military advantages gained must be weighed against the potential harm to civilians. Remember, a blockade that results in significant harm to the civilian population, especially if it restricts essential goods like food and medicine, can be challenged under international humanitarian law. The Fourth Geneva Convention, for instance, prohibits the starvation of civilians as a method of warfare. Also note that Article 7 of the Rome Statute of the International Criminal Court defines crimes against humanity in part as, quote, deportation or forcible transfer of population, which means, quote, forced displacement of the persons concerned by expulsion or other coercive acts from the area in which they are lawfully present, without grounds permitted under international law, unquote. Furthermore, Article 8 of the Rome Statute defines war crimes as, quote, number 1, intentionally directing attacks against civilian populations. Number 4, intentionally launching an attack in the knowledge that such attack will cause incidental loss of life or injury to civilians or damage to civilian objects. Number 5, attacking or bombarding by whatever means towns, villages, dwellings, or buildings which are undefended and which are not military objectives. Number 8, intentionally using starvation of civilians as a method of warfare by depriving them of objects indispensable to their survival, including willfully impeding relief supplies as provided for under the Geneva Conventions. Now, why does this all matter? Here's why it's important, folks. Currently, we have the largest fleet of warships NATO has ever assembled, gathering in the Eastern Mediterranean Sea. In addition to U.S. carrier strike groups and an amphibious assault force, several other warships from other NATO nations are joining its ranks. China has sent several military vessels to the Mediterranean, and Iran is threatening to get involved if there is a ground invasion of Gaza. This is not directly about Israel. This is not about Palestinians. This is about stoking the flames of World War III. Remember, World War I started with the assassination of Austrian Archduke Ferdinand in 1914 by a Serbian national, which resulted in Austria-Hungary declaring war on Serbia. That resulted in Russia mobilizing its forces due to its alliance with Serbia, which led to Germany declaring war on Russia. These concerns about World War III are not exaggerated because the involvement of superpowers like China, Russia, and the United States risks making this regional conflict turn into a global one. So let's all hope for peace and security in this world. See you in the next video.